A very warm welcome to all our participants today. Thank you for joining in for this important session on wills and succession planning. I am Stephen Fernandez. I am the founder of Proficient Financial Planners. We are a fee-only SEBI-registered investment advisory firm. We have with us Advocate Sanjay Rego. Sanjay has over 2 decades of experience in advising on wills, trusts, and family settlements, etc. He also advises on public trusts and foundations, property law related matters, including title checks, documentation, legal due diligence, and commercial corporate issues. His forte is wills and succession planning, and Sanjay is an advocate high court. So, welcome Sanjay to this important session. Thank you.
Yeah. Thank you, Stephen, for those kind words of introduction. Thanks a lot.
Most welcome. Just to get us started, let us start with something very basic. So, what is the fundamental purpose of a will in the context of succession planning?
So, wills are the simplest form or simplest tool, should I say, of succession planning, by which testamentary document one can, seamlessly pass on one's wealth to the next generation. It's simple and easy to understand and easy to execute as well. Of course, there can be situations which can dovetail, complex issues and to provide for certain contingencies, certain events and certain scenarios. But by and large, as compared to any other tools of succession planning, wills is considered to be that testamentary document where one can bequeath one's assets to certain persons as per one's desire, to the exclusion of certain assets to others, etc. So, that is what it is. For example, you can bequeath certain assets to certain legatees, loved ones, certain assets to some others. You can do some philanthropic bequests. You can provide for your minor children, provide for aged parents, special situations and all. So that's what a will can help you to do.
Okay, thank you. Can you explain the key components that should be included in a well-structured will?
Okay. In a well-structured will, the key components should be, some of these which are basically, important. That is, all information about the testator or testatrix, including their personal information, their age, their family profile, their family situations, if any, etc. For example, whether the person is married, divorced, or legally separated, or married, having children, whether they're having minor children, etc. So that could give a background as to what is the profile of this testator or testatrix, as the case may be. The second thing is, though it is not compulsory into inverted commas, but it's always good to have an executor to effect the desires of one's will, to give effect to your will. Now, there could be a scenario where the executor may suffer a mental disability or may predecease the testator. So you could provide for an alternate executor. Another important piece of the will is to provide as much detail of your assets, especially of your immovable property. Movable assets, I can understand that, those will change over time, etc. But depending on who's making the wills and at what age it's made, it is, the asset component should be laid out. Then, in case one is having dependents, provision for guardianship, provide provision for trusteeship of the minor child or the special child, etc. Another very important part is the asset distribution. To whom are you distributing? What assets should be very clearly laid out. You may want to have some time horizons over which people can, the legatees can get the payouts, etc. And the last but not the least is the choice of witnesses. Choosing the right witness to lend credibility to the execution of the will, to my mind, is of paramount importance. there's no point having somebody whom you're not going to be able to trace if that person is called to give an affidavit or give evidence. So who the witnesses are is very, very important. Yeah.
Thank you. Yeah. Let's come to the will document. Uh, so we get different kinds of will that people make. I just want to ask you, is a handwritten will accepted by law, or it should be drafted well and typed and printed out and then signed? Or what is a form of will which is accepted by law?
See, a handwritten will is also accepted by law. In fact, that gives, to my mind, a greater degree of credibility because it's in that person's own handwriting. And so that is something that, the wills made in the, last couple of decades back were handwritten wills. It's only now that we see people who have typewritten wills, things like that. So so the handwritten wills are ones which are accepted. In fact, if one files for probate in court, one gets it based on, see, as long as the will has been found genuine, the will is valid and binding.
Okay.
So it is not whether it's handwritten or it is typographed, but the manner in which the will sets out the requests and the issues therein is more important.
Okay. So which means, as per your explanation, even a written will signed and duly, as you mentioned
Attested by
earlier,
two witnesses is fine.
yeah, and you as mentioned earlier, giving the entire situation of that person making the will in a
Yes,
proper manner also can
yes,
be accepted. Okay.
yes, yes.
Thank you for this. Going ahead, uh, in terms of the legal acceptance, are there any specific legal requirements or formalities that must be followed to ensure a will is valid and enforceable?
So there are certain issues that one needs to keep in mind why to ensure that the will is valid and enforceable. Not that a will cannot be challenged, but for example, the manner in which the will is drafted, the kind of the witnesses that you have. If a person is of advanced age, having a doctor's certificate attached to it, or if there are situations where one foresees that there may be challenges to it, getting a will registered, having, as I said, choice of witness is one thing, but getting all these components in a structured manner can make the will valid and enforceable. For example, if it is found that the person is not of mental capacity, you know, if let us say that it is found that that person is on medication which has limitations to that person's mental health, in the sense the person is having the onset of dementia or Alzheimer or something like that, that will chances of it can be challenged. Or if a person is so unwell and at that point in time the will is made without a medical certificate, it can be challenged. So the scenario as to how, when, and what manner in which it is executed is important.
Okay. Okay. Now let me put three things in front of you. So I have a written will here. I have a will which is duly notarized, and I have a will which is registered. Now, are all the three types of wills accepted for implementation and execution in a court of law?
The answer to that is prima facie yes, if the wills follow what I have said in terms of that. But if it is proven that the will is a fraudulent one, or it has been executed out of coercion, undue influence, okay, that somebody else comes up with a later on will, which overrides this will, you know, no matter whether it's a written will or it's a notarized will or even a registered will, because merely because you have a registered will doesn't mean that the will is sacrosanct. If you have coerced put influence on the testator to bequeath all the property to you to the exclusion of all his heirs and get that registered, it can still be challenged.
Okay.
So whether it is a handwritten, whether it's a notarized, or whether it is a registered will, to my mind, that is not going to make the difference. What is going to make the difference is the circumstances under which the will is drawn up.
Okay. Which means that if there is a written will and if it is not challenged and if that will is forwarded for execution, that will is executable.
Absolutely, absolutely.
Okay. Okay.
Absolutely. But let me caveat it in terms of saying what do we mean by execution. Certain wills, probate is obligatory under law. So where Indian Christians are concerned and Indian Muslims are concerned, the will doesn't need to go undergo a probate. But for say, let us say Hindus, etc., staying in
Just a minute,
the
Sanjay. You can also explain what a probate is to so many
I'll,
people.
I'll come to that. I'll come to that.
Sure.
A probate is a grant of the seal on the will to say that yes, this is the will. Now, in as I said, under certain situations and certain communities, the probate of the will is obligatory, without which execution of the will cannot be recognized. Though people act on those wills. So, for example, if there's a Hindu having property in Mumbai, it is obligatory on him, on his heirs or whoever are the legatees to get the will probated. Similar is for Parsis, etc. So there are some places where will probate is not mandatory. In non-metro towns, it is not mandatory. So if you have property, let us say in say Jodhpur, and you don't have any other property, and you have got a few bank accounts, etc., the probate is not mandatory. Okay, so that is what a probate does. But other than that, for example, for let us say our Indian Christians, if the will is handwritten and it is this thing, it can be executed. Now, uh, though this is the law, let me also state that when one goes to a bank or one goes to execute the will, those guys will say, I get a probate. And then one has to explain to them the probate is not required. When one goes for registration of documents like a transfer, sale happening, sale of property which is under a will of an Indian Christian, sometimes the registrars want to pose questions. So, but technically speaking, the wills can be executed.
Okay. Okay. And it also depends, as you mentioned, that in non-metro the rules could be different, and metro
Yes,
the rules could be
non-metros, depending on the religion, etc., it can be executed or not executed. I mean, will doesn't need to be probated.
okay. 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 Thank you. So, who can be named as beneficiaries in a will, and are there any limitations? For example, can wife be the executor as well as the beneficiary?
Okay. Now, anybody, whether capable of holding the assets directly or indirectly, can be the beneficiaries. Who is a beneficiary? Beneficiary is somebody who gets certain benefits under the will. Okay. So you can have a person, a natural person, you can have bequests to charitable organizations, you can have bequests in favor of minor children, where you appoint guardians for to hold the property for them till they attain the age of majority. So anybody, irrespective of whether they are capable of holding it or not, can be the beneficiary, subject to somebody holding it in trust for somebody who's not capable of holding. You can bequeath for the benefit of special children. So anyway, so beneficiary can be anybody. Okay. Uh, the executor is somebody who executes the wishes under the will. So a person can be the executor and can be the beneficiary. There is no harm in having an executor and the beneficiary. Now, in very closely knit families where, let us say, there's only the father and the son around, and the wife has predeceased the father, and there's no other heir. I mean, why would you want to have outsider as an executor? You will have the person to be the executor and the beneficiary.
Right.
But under Indian Succession Act, where Christians are concerned, I mean, it is best avoided that the person who gets a benefit under the will is not a witness.
Okay. So the beneficiary
So
can be an executor as well as the beneficiary, but not a witness.
preferably not to be the witness. He can be
Okay.
a executor and he can be a witness, but he cannot be executor, beneficiary, and witness. Then his bequest will be void to that
Okay.
extent.
Okay. Okay. All the three should not be there. Okay.
That is that, but otherwise, a beneficiary and an executor, yes.
Okay. Okay. So what responsibilities does an executor have, and how should one go about selecting the right executor for the will? Like you answered the question, when there are not more than one or two members, it's very clear that you would like to appoint a family member as the executor.
Correct, correct.
In a big family, how does one go about appointing the executor,
See,
and how do you
It all
select?
it all depends on what is the testator's estate, the person making his will. What is his estate like? What is his family like? What are the kind of properties he has? What are the kind of bequests he wants to make? What are the complications surrounding the assets which are going to be under his estate? That will determine as to whether he wants to have a family member or an independent executor or a mix of both, family member and an executor, or have three executors, depending on what it is. It is not fixated that you should have one executor. What is more important is the more independence in the discharge of duties that the executor enjoys is what will be best. So, for example, if you have a number of children and number of properties, okay, making a child, and this is more practical than anything else, making a child who is probably getting a lion's share in the estate the executor will tilt towards the fact that there is some you want to give him some extra control over the assets being distributed. So it is better to choose somebody as an independent executor along with the person to see that there is independence and integrity in the distribution of the estate. And the roles and responsibility of the executors are to keep the assets under his control. They may not be physical control, but the kind of symbolic kind of control. Okay. Uh, Ensure that incomes are accounted for, expenses are met, taxes are paid. If there is any litigation on the property of the estate, that is defended till the assets are distributed. The assets are invested in a manner that brings in income into the estate. In short, an executor performs the role of a trustee into inverted commas, and is accountable to the beneficiaries. And if he does not discharge his duty in a manner which is in the interest of the beneficiaries and in accordance with the directions under the will, he could be sued by the beneficiaries. For example, if let us say the executor does not discharge his duty, he sits on the will and does not do the distribution. Okay, then the legatees can take the executor to court or get the executor removed. So dealing in a credible manner with integrity is the responsibility of the executor.
Okay. Thanks. I'll ask you, probably you've answered part of the question, but there is one question related to minor children and special children.
Yeah.
What happens in case where when somebody wants to give part of the estate or part of the benefits to their minor children and or special children? So what care one needs to take to ensure that their needs are being taken care of?
So what happens typically is where minor children are concerned, you want to ensure that there is protection to the corpus, which is bequeathed for their benefit. You want to ensure that those assets are well protected. The assets are invested till they attain a particular age or attain the age of majority. You want to ensure that in the event you are not there and the will comes into force, their education is met, their maintenance is met, their medical care is taken care of, their marriage is taken care of. So all payouts are not done at one go. That's over structured periods of time, so that wealth does not come to the child, at an age of 18, let us say. You may want him to get the wealth at the age when he's far more mature. So one can either create a testamentary trust through the will, or if the wealth is not too much, one can have what is called as a constructive trust through the will, getting a guardian appointed to hold, guardian and trustee appointed to hold the assets in trust for the benefit of the minor children, especially when the minor maybe say 15, 16, and in few years you want to give it to them. So you can do a constructive trust rather than doing a testamentary trust. You could have a testament. What is a testamentary trust? A testamentary trust is a trust carved out of the will where a trust is created. An instrument is created, trust is created where the wealth sits in the trust. There are trustees who are going to keep custody of these assets for the benefit of the legatees who are going to be the beneficiaries, and payouts are made, investments are made, etc. So this can be done for minor children. It can be done for children with special needs, notwithstanding the fact that they may have attained the age of majority. Still, because you are not capable of holding assets, you can have a testamentary trust in place. Okay. So, or you want to provide for aged parents, etc. So you can create these constructive trust provisions through your will.
Okay, so the trust you're saying needs to be created during the rewriting of the will, or it happens post the
So there are
will?
two mechanisms to which you can do it. One is you can create a broad structure through the will to direct the executor to settle the trust and appoint trustees, and then say, hey, executor, you be the settler under the direction of this will and settle XYZ assets in the trust, and appoint a successor trustee through under my directions, etc. That is one way of doing it. The second is having an annexure to the will in the form of a proper trust deed, which is a specimen trust deed, which the executor has to follow and create the trust out of the will. A third way of doing it is a trust is already set up during your lifetime, and you are making a direction that the assets be settled into that particular trust after one's lifetime.
Okay, okay. There are three options available.
Yeah.
What are some common causes of family disputes in a will, and how can they be prevented or minimized? Of course, one is that one has to very clearly specify things in the will, but how can one typically take care of issues which may create disputes, and how does one take care of those things?
See, it's a very sensitive issue when it comes to drafting one's will. Now, let us say one has two children and you have two assets. Okay. I have seen cases where the executor has said, I bequeath both my assets to my children equally and absolutely. So both of them have got a right in both the assets. Now, what happens is if one child is abroad and the other child is here and is in possession of the asset, the one abroad is only there as a legatee name and is solely dependent on how the other child will act or react to give him his or her share. So bequeathing separate assets to each child, if it is possible, is a better mechanism to avoid these disputes. Secondly is, while you may want to give certain assets to the exclusion of one or to some, okay, creating a sort of a balanced architecture to the will to the extent possible. I'm not saying it should be equal. Otherwise, you will say, what's the point in making the will? Need not make the will at all. But you may want certain assets, for example, certain business assets you may want to give to a family member who's running the business. You may want to provide certain income streams to somebody who's not in the business. So you may want to provide, life interest to one's wife. So there are various permutation combinations. So by spelling out all these issues in your will, you can avoid a family dispute by creating these kind of compartments and creating the structure in a manner that each one gets his or her share. Unless one is categorical about disinheriting somebody, one, in my opinion, should leave something on the table for a beneficiary so that he doesn't, unnecessarily challenge the will. So you may say, okay, my son has looked after me and is doing everything for me, etc., etc. So one should make those statements, to my mind, rather than just, there's the, a sort of reasoning as to why you're inheriting or disinheriting somebody to the extent possible, especially when there are complex family dynamics and complex assets in question.
Okay.
It will go a long way in minimizing the challenge to the will. As I said, not that a will cannot be challenged, it can be challenged.
Right. Right.
Yeah.
Just a follow-up question on that. So if a family has got two kids and they've got both movable and immovable property, uh, so just have one immovable property and rest is all on financial assets. In that case, and if the family or the person making the will wants to give equal share to both the kids, but there is an immovable property, how does one solve that issue? What is the better way to bequeath that asset?
See, it depends on what you want to do. For example, you may want to say, okay, I bequeath the immovable property to my son, but direct him to pay 50% of the value of the property to the other son.
Okay.
Or you say, look, let this asset be sold and the proceeds divided equally between them.
Hmm.
Because if you say that this asset goes equally to both, see, as long as the parents are around, there's unity between them. After that, there will be the challenge which I spoke about. One child will go and occupy the place and then say, okay, I am in possession, you go and get a court order.
Hmm. Hmm.
Or you go in for a partition suit and all that. So then to avoid that unpleasant situation, it's better to compartmentalize and say what is what. If to the extent it is possible to do that.
Okay. So what comes out of our discussion is that how much clearly you specify in terms of the distribution will help ideally.
Yes.
Yes. What is the best way to transfer house property to the surviving spouse or kids? And does nomination in the housing society entitle the nominee to become beneficiary in the absence of a will?
Uh, to be frank, there is a lot of confusion around nomination, and people in the yesteryears were thinking that nomination tantamounts to ownership, which is not so. A nominee is only a trustee,
Even in property.
and yeah, is only a trustee. A nominee cannot sell. So, the person being a nominee, if you don't have a will, the interstate law, be it if you're a Christian, what is the intestacy law? If you're a Hindu, Parsi, Muslim, those laws will prevail. So let us say if you have a house and you've got 3 children and a wife, and the person is a Christian, 1/3 will go to the wife and 2/3 will go to the children. Now, if you want to protect the wife, you may want to bequeath her the whole property or give her life interest at least till she's around. So it is so merely by making a person a nominee doesn't protect one ownership. Is my submission.
Okay. So basically, you're saying that in the event of only nomination being there and will not being there, then based on the religion, the different laws of interstate apply.
Except for two situations. One is if one has nominated one's loved one for a insurance policy
Okay.
and has not made a will,
Hmm.
or one has made a nomination to a provident fund account.
Okay. So barring
Those are the
insurance
two
and
exceptions to that.
okay, thanks. Can you mention what are the typical costs that are involved in making a will, ideally, and that's one part of it. And second is for execution of the will.
You're talking about costs only.
Costs, yeah, yeah.
So basically, it depends on, see, it is each lawyer or estate planner will charge their own fee depending on what is the kind of will, time, complexity. There are no standard rack rates in terms of what it is. Somebody may charge, 5,000 for a will. Somebody may charge 25,000 for a will or 15,000 for a will. It all depends. If one goes to a law firm, the charges will be higher. What is more important is the complexity and the time that is taken for making a will.
Right.
So, for example, the more complex issues that have to be articulated in the will to address these issues to ensure that there are less of challenges is what will drive the cost and depends on who. So it is nothing structured that I mean we can say it is between 5 and 7,500. One can say 10,000. One can say it's nothing fixated in my opinion.
Okay, sure.
But when one goes to court and gets the execution through court, then those charges are different.
Okay. Now, in case where there is no will in place, we have seen that for transfer of property or for transfer of assets, which are more than 5 lakhs in the case of shares, etc. Normally, the companies or the investment companies they ask for succession certificate. No?
Yes.
What's the typical timeline and the costs involved in the absence of a will if one has to do a succession certificate?
Minimum is a year's time. Though technically speaking, one should get a succession certificate in 6 months' time, but that does not happen because there is such a backlog and so many, particularly after COVID, when there were a number of cases that came out that and also now, for example, in Mumbai with the Maharashtra Cooperative Society Act making it obligatory to get these letters of administration or succession certificates in place or wills probated, that takes minimum is a year minimum.
So you're saying that even if I make a will and in my absence, the will has to be probated to take possession of the property.
No, I'm not saying that. For Indian Christians, you do not need to probate the will.
Okay.
I am saying in the absence of a will, you'll need to get you'll need to get succession certificate if it's only movable assets, or you'll need to get letters of administration if there are movable and immovable assets.
Okay. Okay. Moving ahead, what will be the best situation for someone who's got kids living abroad? So parents are here and they've got kids living abroad. So if they want to make children as the beneficiaries and they're not being here, what would be your advice? In what way can they make? Who should be the executor? What some advice can you give in terms of?
See, for executor, you can, as I said, you can make anybody an executor, but it is best to make an Indian resident the executor, somebody who is in India. No point having a child who is abroad to make them person an executor because he or she has to come down to effect the execution of it. That is number one. The second is, what was your second question? Your question was regarding what kind of execution should happen.
Yeah, I mean, who should be the executor in the absence of kids not being here, living abroad?
So, yeah. So, to my mind, a family member or an independent executor can be. As I said, nothing prevents the family members living abroad also to be an executor, but it is preferable that he or she is not the sole executor unless the assets are so few in nature that one can manage it.
Okay. Otherwise, it's advised that in the absence of kids not being here and living abroad, even an external executor is
Yes,
always advised who lives in.
maybe a cousin or an aunt or uncle or a nephew or niece can be the executor.
And the case of large assets, it's better to have companies who provide these services, right? Execution
No,
services.
not see that also depends. Having corporate executors is one part, but you can still have your lawyer, your chartered accountant as an independent executor. So it depends on what are the size of the estate. If the asset size, suppose there's a family having business assets, having large financial assets, having number of properties. Okay. A family member being an executor may not have the skill sets to manage that all that kind of wealth and do it. So one may think of having a corporate executor to help.
Okay. 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 Today we live in the world where people have digital assets also. You know,
Yeah.
so they could have social media accounts, cryptocurrencies, or online financial accounts. How are these addressed in the will?
See, uh, depending on how valuable your information in your social media accounts is. For example, you may have information in your LinkedIn account, information on your Facebook account, your Twitter account, whichever. I mean, I am not as technologically
Right.
savvy as probably some of the participants here, but one can make a specific clause in a will saying who those digital accounts or the contents of the digital accounts. The digital account cannot be bequeathed, but the contents can be bequeathed depending on the terms and conditions of that particular service provider. You
Right.
can keep that password unofficially, you can keep it with the person concerned and say, hey, you know what, something happens to me. This is my password, and you can take the contents from there, whatever. You may have some photographs, etc., all that in it. So you can do that. Because if you don't, it still covers under either the clause on rest and residue of the estate or under movable assets. So it gets covered if you have that. Now, if you've not put a rest and residue clause, or you're not covered movable assets, and let us say you've just put immovable property, then the person would have deemed to have died intestate, that is without, bequeathing it through the will. So then that is a complexity which legal heirs will have to address.
Right. One last question before I move to the audience for Q&A. How do we bequeath gold? For example, people have gold jewelry, people have gold in different forms. What will be the best way to bequeath that if they have 2 or 3 kids?
So I have seen people who have taken the trouble of keeping them in various packets with their names and kept it in packets and pouches and said, this pouch is for this one, this pouch is for this one, this is for this person, or gold coins worth so much are for this kid, this. So keeping that in the lockers, etc., all that, or in the house as a case may be. So, or some may have jewelry which they want to describe. So they may create, actually, I've seen a couple of cases where they've actually not only listed out those jewelry, but I've also gone to have photographs of the jewelry, kind of jewelry, and attached it to that.
Okay.
So it's all, it depends on what kind of detailing they want to do.
Okay. Okay. Okay, I'll open it now to questions. You can either post questions on the chat and I can read out, or you can unmute yourself and ask questions. I already received one question. I'll just ask this question. So the question is related to transfer of flat in cooperative society. One is, can it be done by will, which you mentioned, yes, or needs legal certificate and probate? How to get these documents? Is it compulsory? I think you've already answered that in the absence of a will only, then you have to.
So let me give a little more, outline or detail to this. Generally, while you may have a will, suppose it's a will of an Indian Christian, accompanying the will should be the death certificate, and there are certain society forms for legal heirs which have to be submitted along with the death certificate and the will and the share certificate, and then the society will transfer it based on that and giving an indemnity to the society as well. Indemnity bond, you do that. So that's the way it's normally done. If there are cases where probate is required, they will give only provisional membership to the legal heirs and tell them that once you get the probate or letters of administration, as the case may be, or succession certificate, we will transfer the assets in your.
But in case of a Hindu, what happens?
So that's what I'm saying. In case of a Hindu, he'll get a provisional membership
Okay.
till he obtains a probate.
Okay.
Once the probate is got, then he gets full membership.
Okay. Okay. So
So
probate.
while he'll have the right to vote, he cannot sell the property till he obtains a probate.
Okay. So probate has to be obtained in the presence of a
That
will.
nowadays, because the MCS Act has been amended, these societies are now insisting on that because of a lot of family disputes which are happening around that. Because people are just acting on wills, although it required an obligation to a probate. People are acting on it and selling the property. The person buying it takes the risk of buying it without having a proper title. So that has now been amended accordingly.
Okay. Okay. Another question, in the case of a single child, does he or she become the legal owner of the estate?
See, having a single child doesn't, until and unless one makes his or her will. Though under Christian law, let us say he has only the child, he does not have a spouse. It devolves on him. Tomorrow, if that child wants to sell the property, how does the buyer know whether there's one child or two children? So he will say, hey, you know what, get letters of administration from court to protect himself.
Hmm.
So merely because you're the single child doesn't automatically into inverted commerce ensure that you are the beneficial owner, legal and beneficial owner.
Okay, I'll open it to the participants. Anybody wants to ask a specific question can unmute and ask.
Hello, I'm Marathe here.
Yes, Mr. Marathe. Yeah.
Good evening. Yes. How long this will is valid? Suppose
will
I'm around
is
64.
good. I beg your pardon?
My age is something around 64. So validity of his will be how long?
Okay, that's a very, very good question, sir. See, the will is valid till you make another will. Okay. So suppose at the age of 64, you have made your will and you survive for the next 25 years. Technically, that will is valid. But to avoid somebody putting up a fraudulent will after your lifetime, it is always better to refresh your will at least once in 5 to 7 years, if not shorter period of time. And the will is valid till eternity. I mean, that's the document which hands over gives a bequest to your legatees.
Okay, and one more thing, there may be the changes in FISA and US, so we can incorporate that also in the
So
revised will.
I'm coming to that. The will is not something that, once you make the will, you cannot change it. You can change it as and when you want, as per your desires. On the contrary, if there are situations which warrant a change of the will, one should do it. For example, if somebody is married or somebody is divorced or legally separated, or a loved one has passed, predeceased the testator or testatrix, or one has sold some significant assets or bought some significant assets, or there are special situations which need to be provided for. One should always, in my opinion, change one's will to tailor make to those circumstances. Otherwise, you made your will at the age of 64 and 20 years down the line, a lot of water thrown under the bridge. That will may not practically hold good.
Okay, good.
For example, suppose a person has survived his or her legal heirs. Then what happens? And the legal heirs have, no longer the beneficiaries. Then it is as if to say one has died intestate. So, factoring all these situations, one will need to change one's will.
I have a question. Hello.
Yeah.
This is Paresh here. I'm 64. If the beneficiary in the will and the nominee is the same, do we still need to have a probate or a heir certificate for transfer of flat in the residential cooperative housing society?
Yes, to my mind, yes. Because see, the society will transfer in the name as a nominee. Nominee is going to be a provisional member in the society, assuming the society is in Maharashtra. They will not grant grant the person full membership. So as I said earlier, while you can vote, you will have to get, you can't sell that asset unless, you get a probate.
Which is the authority to get the succession certificate?
Succession or letters of administration is the Bombay High Court in Bombay. If you have all your property and one is domiciled in Thane, then you will have the Thane court or Pune as the case may be.
And is it compulsory to register a will? Does it help in getting probate quicker date?
No. It is a good practice, but an unregistered will can override a registered will as well. So unless circumstances warrant you to have a registered will, it's not compulsory.
And last question, my children are both NRIs. So what specific care we should take for considering them as a beneficiary in the will?
See, it depends. This is a question, good question. This is another thing which I wanted to lay emphasis on. While structuring a will, one should also see the domicile or where the legatees are based out of, especially if one has significant wealth to transfer to them. For example, suppose one has NRIs in US or UK, and they will not want the wealth to come directly to them. So that is one thing. Or they may not be interested in holding immovable property. They may say, Daddy, just sell off the property and I will only want the net sale proceeds. So one has to factor those considerations when one writes one's will. You can set up a trust for them if the wealth is significant, or you can say, sell off the properties and then credit it to their NRO accounts, and up to $1 million US dollars, it's allowed to be repatriated freely per year, which is done under a will.
Can we will it in the name of grandchildren who are US citizens?
Yes. You can do what is called as generation skipping. You can bequeath it directly to the grandchildren.
Grandchildren
For the benefit of the grandchildren. No harm, no problem.
But they'll be minor.
Yeah. So you can make their children, you can make your children as their guardians and trustees, and bequeath it to them accordingly.
Also, say in US, they have a system of creating a trust.
Yes.
Okay. So we make the trust as a beneficiary, or we make as an individual members or the trustees as beneficiary?
What you can do is create a provision for telling them to create a trust abroad in accordance with the applicable law. So under your direction, they settle a trust for the benefit of their grandchildren and let them settle the assets there.
Yeah, one more question from Maratha here once again. Is it necessary that the beneficiary should also know what are the provisions made in the will? Is it mandatory or it is advisable?
It is not mandatory. But as going back to one of Stephen's questions, how to avoid family disputes, there are cases where, the parents discuss into inverted commas with the children. And to my mind, discussing with the children doesn't make it your will. It becomes their will. So, they will say, no, I don't want this kid like this. I want it this way. And, then it is factoring their desires rather than your desires.
Okay, so it is better not to disclose the beneficiaries what exactly I want to do.
You may at best tell them, look, I have made a will and the will be kept with so and so person or something like that. But to tell them, look, I have given you X, Y, Z. Informally, you can do that. But point is, it's not mandatory. You may do that to so that there's no dispute later. Sorry. But then it loses the desire that you have. If your son or daughter says, no, I don't want that flat, but I want the monies in your bank accounts, then are you going to change your will according to their desires?
No, that is not the case. So it is better to keep them informally involved, but don't get while writing the will. Just keep them informally informed.
Yes.
Okay, thank you.
Yeah,
Mr.
I have
Manoj, you
one
have a
question.
Yeah, sure, go ahead.
Yeah. So in the absence of house owner, if the nominee is by default wife, okay, which has been there in the society papers, so is she having the rights to sell that property, or maybe the wife may be having, 2 to 3 kids, and if she made a will saying that maybe
She can bequeath only to the extent of her share in the property if the husband has not made his will.
okay,
So it doesn't, no, merely because she's the nominee, doesn't mean that she can bequeath the entire property to her children. Because, say, for example, she's a Hindu.
yeah,
Class one heirs are the wife and the children, let us say. And there are 3 children and the wife. So wife has a 25% share. So she can't bequeath the share that she doesn't own. She can bequeath her 25% to the children equally, such that they, then they will have to get letters of administration in respect of the father's estate to that extent.
okay, thank you.
There is another question.
Can a flat be sold before a probate is obtained?
People do that and make a provision for that, saying, look, but technically speaking, one should avoid doing it. But there are buyers who say, okay, we'll just give me a copy of the probate, But technically, if a probate is mandatory, one should wait till the probate is granted. Because there could be a challenge to the probate. What happens if there's a challenge to the probate? Then your title is not clear. And you may become, you as a buyer may become a party to that suit.
Yeah, Sanjay, any specific challenges or any cases you have handled where a written will was there, not registered, but while getting a probate, there was a challenge in terms of,
No, I have not got a challenge to a written will which is not registered. I have challenged a will which was written where even a medical certificate was taken that the person was mentally fit to make his will. Where I was fully aware that that person was not mentally fit. He was under medication. So, and then that matter got settled out of court.
okay.
During the execution of the will, can there be any changes in the actual execution than what is mentioned in the will by amicable understanding?
No, in the sense, I didn't get you. Can you give me an example? What do you saying?
Like suppose I have been given say 1 crore rupees out of the will, but I want to share it with my brother and my sister. So can it be in the execution will? I can include that as an execution clause and do it?
No. So what you can do is, first and foremost, the will comes into operation after one's lifetime.
Correct.
Okay. So assuming, let us say your father would have bequeathed you 1 crore of rupees or 2 crores of rupees and has bequeathed, say, 25 lakhs to each of your other siblings. So to avoid a family dispute, you may say, all right, I will gift you, a certain amount. So you have a kind of a family settlement and gift it to them and take a discharge from them.
No, so I take it and give it a gift, or can distribute directly from the will,
No, as a gift.
As a gift.
See, whatever comes to the will is a bequest. Now, for example, suppose I have seen cases where the wills are very complex, and there is a lot of ambiguity in what has to be bequeathed to whom. So one can enter into a family settlement to accept the will in principle and then decide between the siblings that, all right, you take this asset, I'll take that asset, etc. If the testator or testatrix overall intention is that everybody gets equal share in the estate, or that there should be, harmony between them.
Okay, Mrs. Manan, you can ask the question.
Yes, thank you. See, I have a couple of questions. One is, I'm speaking on behalf of Mr. Menon as well. We have one daughter. So everything goes to her, of course, but we would like to register a will first. So firstly is, could you please explain like whom to approach and how do we go about making the will? Is there a specific procedure to follow? And once the will is done, where all should we submit the copies of these will? Is it only when the institutes or the financial institutes claim we need to submit? Or is it that we need to maintain multiple copies of the will?
Okay.
That is one question.
Hmm.
Should I
Yeah,
move
carry
on?
on.
Yeah. Next is in the will, as you said, we could mention in a structured way about the movable and immovable assets. So, for instance, now cash, gold, shares, and investments, and all that, do we have to specifically mention what quantity or what amounts, or can it be a generalized mention with
So,
respect to movable assets?
yeah. So, see, it all depends on, for example, let me talk about the registration of the will.
Yes.
There are, once you execute, you can execute the will before at the registrar of sub assurances. That is the registrar where you register immovable property. So you can register it there. Okay, there are registration agents which will help you to register the will. That is point number one. You'll have to take 2 witnesses there, take a medical certificate that you're mentally fit to make your will, because that is what the registrar insists on. That is where registration is concerned. The second aspect of it is, if you have only one daughter, okay,
Yes.
you may or may not want to, list out all your assets. You
Yes.
can keep a listing of, especially movable assets, you can keep a listing outside the will. But say my estate comprises of all my monies in my bank accounts, my investments, including mutual funds and shares, etc. Because what may happen is, suppose you are of the age of 40 or 50, okay, and in normal circumstances, you may survive for a few decades more. Your movable assets will undergo a transformation.
Yes.
You may acquire more immovable property, you may sell off your liquid assets. There may be a situation where you may need to, provide for your medical treatment, etc. So, if you put, 5 lakhs in this account, 10 lakhs in this account, etc., that will keep on changing. Then you may have to, every 3 to 5 years, change that. But if you keep that, and especially if it is going to one legatee only, there is no need of putting that down.
Okay.
So suggestion is, movable assets, keep it more generalistic in nature. But where immovable property is concerned, you may put the name of that immovable property.
Okay. Okay. And also, as I asked earlier, the will, the multiple copies of the will have to be maintained, or is it that like my daughter has to be in possession of the original will always?
See, it again, now this is something which is family oriented, in the sense that, let us say, it's only you and your husband and your daughter.
Yes.
Okay. And obviously there'll be nobody to challenge this will.
Yes.
Okay. So you make original has to be only one and only one original.
Okay.
Don't keep multiple copies of original will. Don't execute it in duplicate, triplicate, etc.
Okay.
Keep one original will. You may make copies of the will and keep them differently. Like, for example, you can keep it with an executor who may not be a family member. Suppose your daughter is in US. You can make some Indian as an executor and keep that original with the executor and keep the copy with your daughter, etc.
Okay.
But the point is, no point in keeping multiple copies, and the question of giving to financial institution does not arise, because a will comes into operation only after one's lifetime.
Yes. So it would be only when she claims, isn't it? That is, God forbid,
After your
on our
lifetime
death.
and after the lifetime of your husband, suppose,
Yes.
God forbid, if something happens, suppose you make a will saying, I bequeath everything to my husband, and in the event he predeceases me, then it goes to my daughter. Then if that event happens, then she will be entitled to it. But till your husband is around, she is not entitled to it. Then it will form part of his estate. And he should make his will then. you know,
Okay.
to provide for her.
Okay. So we can jointly make a will?
Jointly is not practically recommended, though there's nothing preventing you. Joint is more for those as where you're having common holding of assets.
Okay.
Suppose you're having common holding of immovable properties. Because what happens if your husband wants to change his will then? Then technically speaking, it becomes difficult to change the will. Then, and you don't want to change your will. Then what happens? So it is best to make a mutual wills or make separate wills rather than making joint wills.
Thank you.
So so what you're saying is that in a property where there are joint holders, husband and wife, you are saying that only in that case a joint will is better, right?
I'll explain a little more detail. For example, under Goa law, where they follow the communion of assets post-marriage, all assets are by default equally owned by both of them. So you can bequeath only 50% of your share to somebody else. I didn't want this thing. So the point there is you may want to bequeath your 50% to your wife if a person does not have children. So it can be joint in one will rather than having mutual wills. But otherwise, to have joint wills is a bit of a challenge. You know, especially if the wills require to go for probate. Then how does one go for probate if there is one original will?
So which means if there are joint holders in a property, they ideally make two separate wills and mention their share in the
because
property.
it is tenancy in common.
Right.
It is tenancy in common, and that may be one of the assets which may be joint. Others may be separate. The first holder of a bank account or a investment is a holder of that. Merely because I've added my wife as joint holder doesn't make her the owner of it by default.
Right.
Or tenancy in common does not follow that principle in movable assets.
Okay. Yeah. Any more questions?
Yes, sorry, I missed to ask this. As you said, one original will we have to maintain, and we can maintain copies, right? So
Yeah.
copies, do you mean Xerox copies or do you mean attested copies?
You can either do Xerox or attested, and normally you would keep an original will in a sealed cover so that is not tampered with.
Okay.
Just one question.
Yeah.
So while getting a probate, what if there is no objections from anybody? Can still the court challenge the authenticity of the will, or it directly goes and a probate is obtained?
No. So what happens is typically it's like a public notice given to the public at large and the heirs, etc. All that, and if they don't challenge it, see, unless the court has reasons to believe that, for example, the will is forged. For example, when tendering the original will, if one has the court officer has reasons to believe that that will is a forged will or is not the original will, he or she may refuse to, accept it and may have his objection. But otherwise, in the normal course, I mean, if the legatees are not objecting to it and the legal heirs are not objecting to it, the court will grant the probate.
Sure, thank you.
If let us say tomorrow, after the probate is granted, there's a challenge to the will to say that, look, he has wrongly put some other property in the will, or some wrong declarations have been made by the petitioner, then the court could perhaps take action against the petitioner to that extent.
Okay.
Any more questions?
Yeah. Can I ask a question?
Sure.
Yeah.
Yeah.
See, in case of a scenario wherein a mother has two sons, one of the son doesn't take care of the parents, okay, and mother wants to make a will, okay, where she may exclude one of the son in the will, share in the property. Can that be done?
Yes, that can be done, but she should very clearly articulate that this son is looking after me, has been looking after me, the other son has not been looking after me, and that is why I'm disinheriting him. He's been treating me shabbily over the last few years. He has not been in communication with me. He has abandoned me, and put all those aspects in. So that will make it that much more difficult for that guy to challenge it. He'll have to show circumstances that those statements made were wrong.
Okay, even though the
But
flat,
if she just would saying I'll bequeath it to one son to the exclusion of another, that can be challenged.
okay, even though the flat has come to her name from the husband's name, even she's got the flat from the husband who's no more.
No, but did the husband make a will?
No, there's no will of the husband.
Then to that extent, she can bequeath only her share, as I said. She will have a 1/3 share, and the other two sons will have a 1/3 share. So she can bequeath only her 1/3 share. The son whom she is wanting to disinherit, he will anyway have his 1/3 share. So that tomorrow, if the property is to be sold, a buyer will say, "He, you know what? Let me see the title." And then if he discovers that the husband did not make his will, then he may want this son to be the confirming party or to be a party to the sale agreement.
Okay. Thank you.
Yeah, one more question from my end. I'm staying with my husband where a flat owner was my father-in-law, and he is not having any will. Now the society share certificate currently is with my mother-in-law, and my husband is associate member. So now how to proceed with transferring of property and all. So what is the exact procedure to start with, and how we can do that?
See, your husband is the only child?
No, he's having two sisters.
He's having two sisters. So both the father-in-law and mother-in-law are around?
No, father-in-law got expired.
Okay.
He's not there now, but the mother-in-law is there. But on share
So,
certificate, she is the nominee.
see, she's the nominee. Again, she's only the trustee. So when the father-in-law expired, depending on if you all are Hindus, then depending
Hindu.
on this thing, each of you all will get a 25% share in the property of the father-in-law.
Okay.
So the point is the sisters-in-law, that is your husband's sisters, should execute, and your husband, if he wants to, execute a release deed in favor of the mother-in-law to make the mother-in-law the absolute owner. Then she can bequeath it to the husband. Or at least the sisters should release their rights in favor of the mother. So then mother will have her 75% share and your husband will have 25% share. Then she can bequeath that 75% to your husband.
Okay.
And the release deed should be registered.
Very good.
Okay, yeah, thank you. Thank you so much.
Yeah, there is one query here. If the original registered will is lost, can a copy of that will is valid? One can get a probate of the copy of the will, but one will have to make an application to the court accordingly. And the court, after verifying that that is the copy of the original will, can grant a probate on the basis of the copy of the registered will. And if it is the original will is lost, the registered copy can be certified copy of the registered will can be taken from the registrar's office. Certified copy. So that certified copy itself is valid.
How much time it takes for applying?
That hardly any time. Registered will application will have to be done by the legal heirs, and that can be taken after that. If one has reference of that registered will, on the basis of the copy, one can get a certified copy. It is like having lost your original agreement of sale or a sale deed. Then you can, and you got the registration number, etc. You can get a certified copy from the registrar.
Yeah. Any more questions before we close? So thank you, Sanjay. I think it was a very, indeed, a very detailed session, very detailed talk. So many queries you answered with the kind of knowledge that you have. I think thank you. We all got enlightened in terms of property and many other things that you spoke about. Thank you very much for your time. And I would like to thank you for giving us your time and your knowledge for sharing with us. And I also thank the participants for joining in large numbers. Thank you very much. And you have a wonderful evening.
Yeah, my pleasure. Thank you, Stephen, for hosting this. And thank you, participants, for your patient listening. I know it's a subject which is both sensitive and a heavy topic. Thank you very much. My pleasure.
Thank you. Bye-bye.
Yeah, thank you so much.
That's welcome. Bye.
Thank you.